Ladies and gentlemen, on St. Bridget Bank Holiday weekend, I went with the family to London to see ABBA Voyage. It was amazing, ladies and gentlemen, a dazzling jaw-dropping virtual comeback journey, a real thank you for the music event, completely flawless. Now, compare that to the topic that I will discuss with you today. I know lawyers will tell you that an employer is entitled to construction projects free of defects, in the same way as I enjoyed my ABBA Voyage. But, ladies and gentlemen, the common rule is predicated on a false idea, and that false idea is the existence of a perfect construction. As Judge Newey pointed out in the Emson Eastern case, it is not reasonable to search for perfection in construction projects. Building construction is not like the manufacture of goods in a factory. The size of the project, the site conditions, the use of many materials, and employment of various types of operatives make it virtually impossible to achieve the same degree as one can as a manufacturer. It must be rare, says the judge, in new buildings to have every screw and every brush painted absolutely correctly. So here we are. We have a bit of a contradiction. On the one hand, you are entitled to have the free of defects, and on the other hand, you can't search for perfection. Construction defects litigations, ladies and gentlemen, before you go there, you should really consider the multiple challenges that are ahead of you. Before you start this voyage, you need to go through them and ask yourself the question, is it worth it? Let's have a look at a few. First is time. The treatment of a defective work differs where you are with the defects, where the defects manifest itself in the course of construction, at practical completion, during the defect liability period, or before the statute of limitation period expires, or before an explicit manufacturer's warranty period expires. Now, the first three bullet points are kind of easy because this is the time where you haven't paid the money yet, and you can deduct the money that you owe your design team or construction team, or you can ask them to make good what they have to do. Much more difficult afterwards when you have paid them in full and to try to get them back to make good or fix or have the cost for such reparation. Keep in mind time. The statute of limitation period is a period within which you can only issue proceedings. After that, you're time barred. What is the period? 6 years for simple contracts, and by that I mean not deeds and or tort. 12 years when you're dealing with a construction contract sealed, which we call a deed. Okay, where does it commence? Well, the commencement is slightly different. When it comes to the construction contract, in general, the view would be that that starts at practical completion cert, when the practical completion cert is issued. Not the case for tort, since the Supreme Court's decision in the Brenly case, that is a very important case, very recent case. Not too many people know yet of this case. You can start once the damage, not the defect, the damage becomes manifest. So you need to know where you are is the first challenge. I put explicit warranty period as well because you might have a guarantee or a warranty of some of the manufacturers, and they might give you 15 years, for example, for a roofing membrane. If you do, you have obviously that possibility to go after them for a longer period of time but only within the remit of that warranty, which very often means you can just get the price of the membrane. The next challenge is you have to identify the cause of the defect. My firm works very, very close with expert witnesses. And before we even commence with litigation, we go on the site, we go in the building, we go and check, have a preliminary view of what the extent and the nature is of the defect. And you would be astonished, ladies and gentlemen, how many cases I've stopped at that case. For example, not so long ago, I was called for water infiltration in a big house to have a look at. We went there with the expert, and my expert asked the client, could he have a biro? The client was a little confused, and the biro was given. He called the client and he says, you see those windows? At the end of a window is a window weep hole. And what had happened was, due to the construction, there was all loads of dust, etc. They were blocked. He put his biro in and unblocked them, and that was it, ladies and gentlemen. It was a maintenance issue. So you don't always go straight to litigation. Think about it before you go. And that applies also when you're acting for a defendant. More difficult when you're acting for multiple, or for one defendant, but there are multiple defendants, because people get very nervous. The blame game starts immediately. Lawyers are a bit to blame in that as well, because they're difficult to agree with each other. And yet it works. I have had another big case built at in Doki at the sea. And I was acting for the manufacturer of the paint that you use that was water resistant. So I was only a Mickey Mouse guy in the whole scheme, but yet we were 8 defendants there. Managed to bring all the lawyers together in the room, gave them tea and coffee, and explained to them that it would be good to have one expert preliminary to have a look at it. We did. The expert came. This case, in normal circumstances, would have cost around $500,000 per defendant. So 8, that's around 4 million. The expert came in, realized what the problem was, and the problem was that when they poured the concrete within shutters, they call them formworks, when they removed the formwork, the holes that fixed the two together were not filled. And when the landscape contractor came, he actually put a nice lawn in front of it, very small because the sea was there, and that's where the water seeped in. But because of the construction, the water only came towards the end of the building, so nobody thought of that problem. The problem was sorted, ladies and gentlemen, for €3,000, not 4 million. So you need to be pragmatic in those things, but people get very nervous because there is also what is called the 1% rule, or the Civil Liability Act that is there. The Civil Liability Act specifies that if there are multiple wrongdoers, then the employer can decide to pick one of them. The person, even if that person only has a 1% liability, take the example of my client who had only brought in the supply to paint that was water resistant. If he or she had a liability of 1%, he would be able, a client could go after that person for the totality, and he would then have to try to chase it back from the others if they were still in existence. The importance is that you have to go through all of this and make sure that you have considered all the points, and one of them is the problem that very often people forget is that when you start litigation, you have to have a report supporting the argument that your design team has been negligent. That is a case called Cook and Cronin, where the Supreme Court said you cannot start litigation without having at least a minimum report that confirms the grounds that there is negligence. If you don't, it will be considered abuse of process of the court and it will be thrown out. So be careful. Let's go to the next step, which is typically in a construction project, you have an employer, you have a design team, you have a contractor. The design team will be various teams. It could be the architect, the engineer, the assigned certifier, the health and safety consultant, loads of people, all contracts. And then you have normally the general contractor who would then appoint subcontractors and suppliers. I know you can have a design team where all of that is banked together, ladies and gentlemen, but the points I want you to see on the screen now for a moment is where the defects are. Is it could be a design deficiency, a spec deficiency, or a supervision deficiency of any person of your design team, and that could be a long list of people. Other, in the contractor, it could be a workmanship issue. And the contractor cannot just say, well, my workmanship is, I've done exactly what's in the specification. The contractor has an obligation also to look and give his experience and notify an employer if something cannot be built. And then under that, you have the suppliers, which will provide very often a warranty for their product, but the product could be deficiency, and as Damien from Aon will probably explain to you, the whole aspect of the product liability issue is there. So, ladies and gentlemen, now that we have all that done, when a judge will look at a defect, he will look at that whole matrix that you have currently in front of you. Very important for a judge to go through this, because that's where he will define whether there is an issue, a defect that he would allow to get damages for. The next step is the expert witness. Probably the most important element in a defect construction litigation. The expert is a person that is independent, very often forgotten. Some expert witnesses think they are advocates and they can actually act for and on behalf of their client. This is absolutely unheard of, unaccepted. Order 39 of the Supreme Court rule, which is based on the principle, Icarian reefer principle. Icarian reefer principle is based on a UK shipping case where the judge got really mad with expert witnesses because they were acting as an advocate. The duty of an expert is to assist the court within the field of expertise that they are, which duty overrides any obligation of the paying party. So you may not forget that as an expert, and it is the credibility of the expert that will more often than not win the judge's ear. It's very important to have an expert that realizes that. An expert that tries to push it in one direction, whilst that irritates clients, the judge will be even more irritated when that happens. So the construction defect cases, in my opinion, are more often than not determined by the judge's view of the experts. After that, the experts might be various disciplines, and one of the disciplines will be the quantification of the costs that will have to be analyzed. Now, in strict legal terms, the quantification happens when the damage manifests itself. In reality, it will be the damage when it is reasonable to undertake the relevant works. And I give an example. I have a client of mine, water leaking in the roof, big roof structure, and this case started more than 5 years ago. The parties have not yet agreed what the remedial works are, let alone the costs. But 5 years ago, immediately that triggers off in your head. You say, oh my God, the building regulations part M changed. And you're right, it changed twice actually within that period of time. And because the whole structure, the whole roof has to be removed, we are compulsory falling under the building regulations part M, and that has increased the price from 500,000 to, for the moment, 2,500,000. Now, Could you say we should have fixed it before? No, because we had no agreement of all the parties, we being the plaintiff, but the defendants still wanted to be able to assess the works. And that's important. Being able to assess the works is something you should always allow the defendants to do. I've had a case where I act for the defendant and the plaintiff says, well, the water is infiltrating in my wall, but by the time I sent my expert to have a look at it, the wall was knocked down. Well, then there is no case anymore for that employer. Mitigation of losses. You will hear very often that you as an employer you have to mitigate your losses. Now, there is no such an obligation as mitigating your losses, but if you don't, then it will be taken into account in cost. So you're better off to mitigate your costs, and this is important when you want to have when a builder wants to come back and make good the defects. More often than not, the employer is not keen to see that builder again because he or she was the cause of the defects. Has he or she the right to come back? In principle, no. Unless the contract specifies otherwise, unless the defect liability period has been phrased in such a way that the contractor can come back. But otherwise, no. Employers, I know you work on the basis that you have done no wrong and that it's not your fault. We've already given the example of maintenance, very important. If you don't maintain your building, you could be a very important cause for the defects. Also, if you do not use the building for what it was designed for, you could be liable for it. Take the example whereby you overload your building and it wasn't meant for that, and you get a shear failure. Could be your liability. Or you provide information. Very information that you say, here is information about the site, etc. And imagine that that information is wrong. Now, ladies and gentlemen, it is correct, it is entirely correct, that the common rule for the employer is that you are entitled to a project free of defect. And I told you that it is predicated on a false idea of the existence of a perfect construction. Doesn't exist, okay? So what defects will be considered in law? Well, those that are identified and determined by an independent expert, and those that are defined by the court by reference to the contractual matrix, to the contractual provisions, to the project drawings and specifications, the applicable standards, based on the facts of the case. So the one thing you have to know, ladies and gentlemen, is that litigation is frustrating, extremely frustrating. ABBA said it. Money, money, money. It's very expensive, ladies and gentlemen. So before you go forward, you need to think about it. And ladies and gentlemen, Chiquitita, I told you the truth. And I am very happy to remain the legal shoulder you can cry on. Bon voyage.